Well, the lawsuit was filed in November of 1997. At that point, I was finishing my 6th year, almost 7 years, serving as the Dean of Admissions at the law school. And a person who had applied a couple of years before and had not been admitted filed a lawsuit claiming that she'd been discriminated against based on her race. Well, I think it started when I arrived at the University of Michigan Law School in 1991. And I had a conversation with the dean about my role in making the majority of decisions on who might be admitted at Michigan. And I explained to him that I didn't think the institution had really thought about what it hoped to accomplish with its admissions decision-making for quite some time, since the late 70s, probably prompted by another case, Bakke, and that it was time to revisit that. And what came out of that was a year of work on the part of the admissions committee that he appointed, consisting of faculty, a student or two, and some other administrators, who spent a lot of time thinking about what they hoped to accomplish with their decision making. And then ultimately came up with a policy that ended up being litigated. I think one of the things that people don't understand is the policy wasn't just about race. It was about the larger mission of the institution and how all of their admissions decisions should be in furtherance of that mission. Well, I make a couple of observations. A lot of litigation has come out of this. And I think what most people need to understand is that it only impacts truly selective undergraduate institutions and graduate and professional school. So a very narrow slice of higher education. It's amazing how much time and energy and resources have been put into that. And it's important, I think, to society, that the end product that comes out of those graduate and professional schools is at least somewhat representative of the larger society at large. And that's because, first of all, it prepares the students to go out into, the graduates go out into society that is becoming more multiracial and more complex, and the ability to collaborate across those differences is really important. And number two, that it can impact how and what decisions are made. And I often like to go back to things like redlining, right? Are the lawyers that actually participated in that on the part of the insurance companies, if that group of lawyers had been more diverse, would they have necessarily ended up in the same space? Would those issues have been brought up about the impact that it had? I would like to think there would at least been a discussion and maybe a different outcome. So along with that, what happens in the classroom, what happens in the interactions amongst students, when you make it possible for them to interact with people who come from different places and with different sets of life experiences, I think changes the whole dynamic of what the educational enterprise can accomplish. Well, it's an interesting circumstance because about just over 20 years ago, that same conversation was going on right before the decision was made. And I was of two minds. because the challenges facing society then, and I would suggest you still today, are still going to be present no matter what the outcome. Okay? And the larger societal issues are, I think, the things that need to be part of the conversation. Now, I'm not real certain beyond that. You already see some of it in law schools finally acknowledging that the LSAT is not the be-all and end-all, okay, which has at times been barriers to all kinds of people. I would hope that in a perfect world, what happens is what we did at Michigan, that people will actually spend time reading files carefully and thinking about them and setting sort of the numbers aside. Because when somebody applies for graduate or professional school, what they present is simply a snapshot and not a very full one of where they are at that moment. Okay? And you can sort of extrapolate how they got to that point. But the key thing you want to think about is how they can impact things moving forward, both in their law school classrooms and as they become lawyers and leaders down the line. So the outcome, I'm sure there will be a lot of angst one way or the other, but I would hope as educators that we think of ways to still have a positive impact in the longer term. There's nothing race neutral about any aspect of society. I think one of the principles that the Grutter case stands for is that nobody is automatically admitted or denied because of the color of their skin. Immutable characteristics. Instead, you look at a lot of different things. And in the grander sort of ambitions of the institution, you got to match that to what you think that institution's mission is. There's this notion that everything can be resolved down to some quantifiable merit assessment. Well, I can tell you, over the course of my career, 25 years in law school admissions, tens of thousands of applications read, over 100,000 over that period of time. The numbers can help you some, but it also convinces me that it's well worth the effort to look beyond that, to sort of think about the contributions that someone can make to the law school, to the profession, and society at large. The honest answer is not exactly, but I would suspect that there are fewer African Americans going to law school there now, much as when California eliminated the consideration of race. They have tried for years to find a proxy that would accomplish the same sorts of things. There's not a proxy that addresses at the scale it needs to be addressed at. So my suspicion is that the enrollment both at the undergraduate level and at the graduate professional school level is, in terms of African Americans anyway, less now by a good margin than it was when Grutter was decided. It was a remarkable thing to be a part of that in many ways, because a lot of very, very smart lawyers were involved in it. I was impressed by the University of Michigan and its then president Lee Bollinger's passion for defending this and actually investing in defending themselves in this lawsuit. In some ways, the plaintiffs picked the wrong defendant. They did not know that Michigan would be that passionate about it. Another aspect of it is I always took my work in making admissions decisions very seriously. I was rewarded by following the mission as it was laid out for the university, following the policy and having the Supreme Court, by a narrow margin, see that as an academic institution, we had addressed this problem in the way an academic institution should, and that my execution of those policies was defensible. And that was a remarkable journey to get to that point. Well, here's the thing I'd tell you. Law school is a prestige-driven profession at some level. Mm-hmm. And one of the real frustrations I had when I was a part of legal education is that those law school rankings drove schools to do things, in particular, many schools not to be true to what their mission has been. I think there's good reason for the Southern University Law Center to be very, very, very proud of itself, because in the decisions that they've made, in the way that school has operated, it has been true to its mission. And I would suggest to you, as a law center, it has had a profound impact on the legal profession in this state in ways. The bench is more diverse, and not just based on race, because it's been a point of access for a lot of extraordinarily successful lawyers of all races. That's because they were true to their mission and not to some ranking that purports to tell you what's more prestigious or not.